Hello and good afternoon, everyone. Thanks for joining us today in our weekly immigration update session. My name is Amir Ismail, and I'm an authorized citizenship and immigration advisor based out of Toronto. Those who are joining us for the first time, a very warm welcome. And as usual, the format of our today's broadcast would include updates in immigration industry. Since the time we last spoke last week, there have been some updates happening, and we would be talking about those. We would also be taking some of your questions. And as usual, we always select a topic, an interesting topic that is directly related to our clients' immigration and temporary residence visas matters, a topic that is actually very interesting, and I actually love it. It is about something that a lot of people ignore when they're applying for immigration. When they're applying for immigration or any other visa, they look at their eligibility, they calculate their points, and then they apply. And they ignore something which is, I think, due to lack of knowledge, or maybe they don't give it a lot of significance. But at the end of the day, that thing can cause you a lot of trouble or even refusal. I'm talking about looking at a client's inadmissibility issues. So when a client approaches us, not only that we make an assessment of their eligibility based on their point system, their CRS score if they're applying as a skilled worker, but we also then invite them for a one-on-one consultation with us. And in that consultation, we discuss all the matters associated with a client's file. And that also includes any issues in past related to their admissibility, inadmissibility, their criminality, their misrepresentation issues, medical issues, or even financial issues, because all these things can cause you a refusal. So let me introduce my team with me. Joining me all the way from Karachi, my Asian Regional Director, Khwaja Noman.
Hello, Abrisal.
How are you?
I'm fine. How about you?
I'm doing pretty good. How about the weather? Because I really want to know.
The weather is perfectly fine. In fact, it's good for Canadians like you.
Wonderful. I wish I could travel. I usually travel 2-3 times to Dubai and Karachi as well. But unfortunately, the situation surrounding this COVID-19 has precluded everyone from undertaking travel, and it's actually not advisable. This is not the time to travel, right?
Exactly. And especially when your province is very much affected.
It is. We are under a lockdown situation for quite a while, but it's for the benefit of everyone. So, guys, we are going to take some questions as well, and we're going to acknowledge the attendees today. But let me first introduce more of my team members who are joining me today. Our Toronto office manager, Faria Amir, is also joining us. She's in Lahore right now. Hi, how are you doing?
I'm great. How are you?
I'm good. Thank you very much. And how's the weather at your end?
It's actually all right, to be honest. It gets pretty chilly at night, but at daytime, it's a bit warm nowadays.
Yeah, you can say that because, when you are in Toronto, of course, you always want to go to the sun destinations, which are now banned because we have stopped flights going south, Mexico, Caribbean. So maybe going to a place like Dubai or maybe Lahore makes a lot of sense at this point in time.
Yeah.
We are also joined by our colleague, Brian Paul Welch from Toronto, our city. And Brian is a trained immigration professional. he is going to be presenting the inadmissibility issues presentation. Let me introduce Brian to you. Hi, Brian. How are you?
Hello, everyone. I'm doing well. Good day.
Great. Okay. So, Brian, we would be discussing this very important topic that client would like to know, and they are very interested. I think we have already started receiving comments as to what is that thing that you're talking about that a lot of people ignore, and then at the end of the day, it can cause a lot of trouble and refusal if it is not dealt proactively at the start of the process, or if it is not determine if even applying is advisable if a client is not qualifying, is impacted by the adverse impact of these regulations in Immigration Protection Act surrounding serious criminality, misrepresentation, all these things. And the client should also know if there is a recourse available, because it's not necessary that if there is a problem they might not qualify. They might qualify, but there are steps involved, right?
That is correct. It's a very intriguing area of the immigration practice, and one that is often overlooked. Most of us are concerned about how do I qualify, but we need to be concerned also about what are the things that I may have experienced in my past that if I'm not forthcoming about them, both in my application and in how I present myself to the officer, how can they affect my future? So we need to think carefully about these things. So I have a presentation I'll be sharing, a PowerPoint presentation. I hope to be very brief and discuss a very interesting topic in hopefully a novel way. So I am excited to be part of it this morning.
Perfect. Okay, so let me just acknowledge our attendees today. Mr. Mujib Abdullah is joining us from LinkedIn, and he's asking a question. So Mujib, we are going to take all the questions at the end of the program, especially after Brian's presentation. There is Kazi Suhail is also joining us from LinkedIn, and he's asking about the scope of HVAC skilled workers. So we're going to attend to your question shortly. Please remain with us till the end. There's a big question coming in from Muhammad Hassan Atiq. Muhammad, you might want to send an email to us then. This has covered the entire screen. But thank you very much for joining us today. We'll try to attend to this question at the end. Aji Khan is also joining us from Doha, Qatar. So thank you for your presence. Shazad is joining us, and he's asking about pharmacists. Nice. Ibrahim is also with us. Ibrahim, thank you for joining us again. I think you joined us earlier as well. So we are online every week, Saturday. And today, of course, you might have noticed that I said good afternoon rather than good morning, because it's 12 noon. We delayed it by 1 hour. And I think this might be suitable for a lot of people because they get free on the other side of the world. There is a LinkedIn user. I don't know the name, but there's a question, of course. It's a very interesting question. We're going to take that question too at the end. And Shazad Khanji as well joining us. Before we move on to Brian's presentation, I'd like to touch base on a few updates that happened last week very, very quickly. So Canada, of course, has introduced the new travel restrictions, and people have to get themselves tested once again at the airport. And depending on the outcome of the test at the airport, they are allowed to go or come inside the country. But before that, they have to mandatorily stay at a hotel, a designated hotel, and they have to pay from their own pocket. So sort of a discouragement for a lot of people, but that's how Canada is dealing with the international travelers at the moment. But things are going to be quite okay very soon, I'm pretty sure. The new open work permit introduced for international students has come into effect, and this new open work permit was designed for international students who have their postgraduate work permit expired or their PGWP is expiring. So this would give the opportunity to at least 53,000 international students to extend their stay in Canada and eventually become eligible for permanent residence. On the international front, Canada has signed an agreement with Ukraine, and they are going to expand immigration cooperation with that country. And also, they have introduced a new work permit for Hong Kong graduates. So if you are a Hong Kong resident or citizen and who have graduated, there is selection criteria to that effect. You can get in touch with us for the assessment as well. On the front of the provincial nomination, we continue to see regular draws happening. British Columbia conducted a draw, Ontario conducted a draw, but the very interesting draw that happened was Alberta, and we learned that the minimum CRS that was selected in Alberta's draw was somewhere around 360. So it gives a lot of hope to a lot of people who don't have the CRS points in the vicinity of 460 to 470. So if they are in the vicinity of even 360 to 370 or more, they have a chance in Alberta. But there are other provinces as well, like Saskatchewan, Nova Scotia, Prince Edward Island. So there are a lot of opportunities in the provincial nominee program. In terms of the express entry draws, we have seen there have been 3 draws this year, but none of them have targeted federal skilled worker program, if I'm not wrong. But this next week, we are hoping that there will be a draw. And if that happens, it would be a very good news for a lot of people who have been waiting for quite a while. And that draw is, in fact, going to set the trend as to what is going to happen with the CRS score in future in this year. We are expecting it's going to slide down, but this draw would be very important to see what the IRCC going to do with the CRS score. What is your take on it, Khwaja Sahab?
Yeah, Amir Saab, very most likely it's been almost, you can say, starting from January and up till now, and we are in first week of February and it's almost ending. So we are expecting a draw, and we are all waiting for it very anxiously, because a lot of people are waiting into the pool and waiting for this draw. In fact, a lot of our clients also. But what we are expecting is, yes, we are expecting a slight draw, but nevertheless, we are actually looking forward to it. Naturally, as you said, the draw gonna set the trend for the upcoming draws coming up in the whole year 2021. We have very good hopes in that terms, and hopingly, considering the inventory that we have in hand up till January 18, 2021, we have almost 25,000 people who are above 450 points at this moment. We are expecting the continuous selection of 5,000 applicants per draw, which is expectedly going to happen and have been happening in January. So we are very high likely expecting this draw. If this continues to be happening, we are actually looking this threshold to be reduced.
I'm excited
for the upcoming.
I'm excited to. I'm looking forward to it. Let me just quickly ask Faria the situation in Lahore, because you're being approached by a lot of clients in Lahore and Islamabad, and you are coordinating their meetings with our Toronto team. What is the situation now? I believe what I've seen and what I've heard, that in Pakistan, of course, there is an impact of Corona, but things seem to be quite in control. It's not that bad an impact in that country, right?
Yeah, it's actually, there's a lot of restrictions that have been lifted up, like restaurants and everything, they have been open. To be honest, sometimes when we go out, all you see is masks, but it doesn't feel like that there's COVID around here. I don't know if we're lucky or what, but it's not as bad as other countries at the moment.
My take is perhaps because it's not a targeted tourist destination, so not a lot of traffic coming in, but there might be other underlying facts. Maybe the immune system of the nation is great, which is good, God given, right? Okay. So I'm going to bring in Brian now, and we're going to be He's going to be presenting on a very important topic, as I said, inadmissibility. And as I said, people need to evaluate their inadmissibility, their previous records, even if there is a charge in past. And sometimes what happens is, Brian, I'm just taking a little bit of lead here, but I'm actually very excited about this topic. That's why I'm just giving my 2 cents. Sometimes what happens is that people don't think that a record in their past, an adverse record in their past, is actually gonna be impacting their immigration prospects, because they sometimes, and in fact all the time, they don't compare the penal code with the penal code in their jurisdiction with the penal code provisions in Canada. And the Canadian visa officer is going to look at any offense, any misdeed, anything in your record with Canadian standards. It's going to evaluate it in Canadian standards and determine whether the person is admissible or not. And people are surprised to see that how small offenses can cause bigger trouble. Driving under influence, for example, is something that is seen not a big deal in a lot of jurisdiction, or maybe law enforcement authorities are lenient. Sometimes there's a charge, and then there's a compromise between the victim and the offender, but Canada would take a serious note of it. So I'll give the floor to you without further ado, and let's bring in your presentation.
Yes. Thank you very much, Mr. Ismail. I'm going to attempt to share my screen now.
Sure.
So I'm going to switch to my presentation in a moment. One moment. There we go. And good. All right. I hope everyone can see my presentation. So I'm going to try to restrict myself to 30 minutes. It's a very interesting topic, but I'm going to try my best to keep it short. So in a nutshell, as Mr. Ismail remarked earlier, Canada is very selective, very careful about who it allows to enter its borders for the reasons of safety and security of Canadian citizens. So because of that, the consideration is not only your eligibility, but also secondary to that, what is considered is your inadmissibility. Is there anything about your character, present or past, that can have an impact on Canadian, a negative impact on Canadian society? Or to some extent, will your presence in Canadian society bring an adverse cost to the Canadian taxpayer, one that would be unreasonable for them to absorb? So, as we are all interested in immigration, I should point out that over the next few years, Canada has set a very ambitious target of 1.26 million persons. It's a big number, many of whom are a part of this broadcast today. And they are qualified, and they're ambitious, and they're bright. And there are many that are eligible, but there are quite a few that are also inadmissible. Inadmissibility, the most layman definition, refers to something being not valid, not allowed, unacceptable. It's not tolerated. It is contrary to the standard. So within the context of Canadian immigration rules and under the guidance of the Immigration and Refugee Protection Act, which we call the IRPA for short from now on, there are persons which are considered admissible, and there are persons which are considered ineligible or inadmissible. So the reasons for this could be from any of these general 8 categories: security, human or international rights violations, serious criminality, organized criminality, health grounds, financial reasons, or misrepresentation. So we're going to cover all of these in our discussion today. But as Mr. Ismail pointed out, criminality in general is perhaps the first tier, and the others I will explain thereafter. So if we were to group these by theme, as I mentioned, we would consider criminal issues and we would consider medical issues. The medical issues have to do with excessive demand and cost on public health services, and the criminal issues are, of course, considering public health and public safety. So in summary, foreign nationals and permanent residents can be deemed inadmissible to Canada if, barring any exceptions, their presence will represent a danger to Canadian society due to their criminal acts or omissions, or if their health status will result in danger to public health and safety, as we are now experiencing in the time of a pandemic, and
Yes.
also whether it will create excessive demand on cost to Canadian public health. Pardon me. So our first discussion will be about criminal inadmissibility, our first limit of our discussion. We're going to focus on it under the IRPA, which I mentioned earlier, refers to the Immigration Refugee Protection Act. This, I'm not going to go into the long legalese, pardon me, pardon my cough. I'm not going into the long legalese, but suffice to say, as I said earlier, this has to do with acts of a serious criminal nature that will bring danger to the security of Canadian citizens. So if there has been a criminal conviction, criminal charge, the issue really is about full disclosure. There's a section of particularly the application to enter Canada as a temporary resident, the visa application form, which is often neglected at the very back of it, the very last few pages, where they ask for this disclosure. And people neglect to disclose for fear of it impacting their case, or perhaps for they genuinely may have forgotten that this was a serious issue for them in the past. So this could either be intercepted by the visa officer in their native country, or it could be a matter for discussion when they present themselves before the immigration officer in Canada. So persons are often surprised when they are asked to give account for a past conviction. So temporary residents and those applying for residence as permanent status are considered to be criminally inadmissible if they were convicted of an offense in Canada, they were convicted of an offense outside of Canada that's considered a crime in Canada, or they've committed an act outside of Canada that's considered a crime under the laws of the country where it occurred and be punishable also under Canadian law. So the commission of the act, the conviction of the act are also considered. And these are things which are neglected, they're forgotten, up either at the point of entry or even before that, at the point of application. So one must ask not only the question relating to their eligibility, but also their possible inadmissibility. So we're going to look at some scenarios to see how one would take that into consideration. If an applicant believes he or she may be inadmissible, they must provide an officer with complete details of all charges, convictions, court dispositions, pardons, photocopies of applicable sections of foreign laws, anything. Full disclosure is of utmost importance in these cases. Because if you choose not to disclose fully, the impression could be given that that was a willful neglect. You deliberately withheld information because it would have not been to your benefit. So that would not be very good for your immigration case. So in the case where the applicant knows or strongly believes they're inadmissible, there are steps that they can take to overcome this. For charges that are withdrawn or dismissed, if the offense occurred in Canada, you're not inadmissible. If the offense occurred outside Canada, you may be inadmissible. So there's a distinction. For an absolute or conditional discharge, if the offense occurred in Canada, you are not inadmissible. If the offense occurred outside Canada, you may be inadmissible. And in the case of a pardon, If the offense occurred in Canada, you are not inadmissible if you were pardoned under the Criminal Records Act in Canada. However, if the offense occurred outside Canada, you may be inadmissible. How to overcome this? Convictions that occurred outside Canada, and please note the IRCC makes a point of convictions and offenses. So you may be charged but not convicted. So it is important to make the distinction, to be aware of it, and also to disclose where necessary. And in this case, you must disclose both convictions and or offenses. However, if such an offense or conviction occurred outside Canada, if one were convicted of or committed a criminal offense outside Canada, one way to overcome this by applying for rehabilitation, or if at least 10 years have passed since completing the sentence imposed, if the offense is one that would in Canada be indictable and punishable by a maximum term of less than 10 years, you may be deemed to have been rehabilitated. If the offense is one that in Canada would be prosecuted summarily, and if you were convicted for 2 or more such offenses, the period for rehabilitation is at least 5 years. This 5 years is going to keep popping up. So please make a note in your mind for 5 years, okay? For convictions in Canada, if the criminal conviction in Canada, if there has been such a conviction in Canada, you are to seek a record suspension. It used to be called a pardon, but is now called a record suspension from the Parole Board of Canada before you'll be admissible. Okay? Once you have a copy of the record suspension, it must be sent by photocopy to the Canadian Visa Office. Of course, your consultant will advise you of the process. So you wouldn't be burdened to do it on your own. You'd be advised by professionals who are knowledgeable. But it's a process. And once more, if you had 2 or more convictions in Canada, you may no longer be inadmissible if at least 5 years have passed. So there's that magic 5 years once more. For convictions in Canada or offenses outside of Canada, if you have convictions in Canada and convictions or offenses outside of Canada, both an approval of rehabilitation and a pardon are required to overcome your inadmissibility. If you have a criminal conviction in Canada, you must seek a record suspension, as we said earlier. Okay, moving along. So let's explain rehabilitation for the purposes of immigration. And according to the IRCC, rehabilitation means that you lead a stable lifestyle and that you're unlikely to be involved in any further criminal activity. So if you had a clean record, you've been a model citizen in your time since your offense or since your conviction, and you're able to convince the officer of this, or if it's intercepted upon your application and you're able to adduce evidence that you have been living in a rehabilitated state, then you may very well have overcome your inadmissibility. So, how can one be deemed rehabilitated? For that to occur, the person must not have committed or been convicted of any other indictable offense. And here we are once more with that 5-year period. So one is eligible to apply for rehabilitation if they have committed an act outside of Canada and 5 years have elapsed since the act. They have been convicted outside of Canada and 5 years have passed since the sentence has been imposed. Okay? So I want to look at a few scenarios very quickly as we get to about the halfway point. So if you're convicted of an offense outside Canada, you would be that if committed in Canada would be an indictable offense punishable by a maximum of imprisonment of less than 10 years. You are deemed rehabilitated at least 10 years after the completion of the sentence imposed. And you are eligible to apply for rehabilitation 5 years after completing the sentence. If you have committed an offense outside Canada that is committed in Canada would be indictable, and punishable by a maximum term of less than 10 years, you are deemed rehabilitated at least 10 years after the commission of the offense, and you are eligible to apply for rehabilitation 5 years after commission of the offense. Same applies. That is, if you were convicted of an offense or you committed an offense outside Canada, that if you had committed it in Canada, you'd be indictable for a 10-year sentence or more. You are deemed rehabilitated, and in this case, it is not applicable given the length of sentence. However, you may be eligible to apply within that 5-year period. And in the interest of time, I'm going to keep moving. So this is the interesting part that I think we're all curious about. How do I calculate 5 years? For a suspended sentence, you count 5 years from the date of sentencing. For if there's a fine also imposed along with the suspended sentence, count 5 years from the date the fine was paid. If there's imprisonment without parole, 5 years from the end of the term of imprisonment. Imprisonment and parole, again, 5 years. Remember I said 5 years earlier? Probation. The probation is counted 5 years from the end of the probation period. Likewise, for a driving prohibition, a driving offense, count 5 years from the end date of the prohibition. Okay? So I'm going to give 3 quick examples of persons. Here's Imani. She's the secretary. She was convicted of a crime in December 2002, and she received a jail sentence of 3 months. Is she eligible to apply for rehabilitation? As we said earlier, she can apply 5 years after the end of her sentence. Moving on to Marcos. He's a manager. He was convicted of driving under the influence and had a driver's license taken away from him for 3 years. When can he apply? That would be at the end, well, 5 years after the end of his suspension is when he can begin his application. That is on the date, counting 5 years from the date his driver's license was reinstated, that is when he can begin. Likewise, we're going to look at our last person, Valdia. She's a pilot, and she was convicted 3 years and served 3 years of probation. Her question is, do I apply for rehab after my probation is finished? And as we have seen before, she is not eligible for rehab until 5 years after the end of her sentence has been imposed. So that magical 5 years is very important. So these fees are subject to change, but here's a fair estimate of what it could cost to help you through this process. Now we're going to quickly go through medical inadmissibility as we enter the second half of our presentation. So everyone who would like to live, visit, work here has to consider whether their medical condition can possibly make them inadmissible. So this is legalese once more. I have the act, but in essence, a foreign national is inadmissible on health grounds if their health condition is likely to be a danger to public health, is likely to be a danger to public safety, or might reasonably be expected to cause excessive demand on health or social services. Now, there are exceptions which we will get to later on in the presentation, but I want you to be aware of the general issue. And the general issues are danger to public health, danger to public safety, and excessive demand on health or social services. So let's take a look at the issue of danger to public health. The issues that are taken into consideration when you apply are your immigration and medical exam results, lab results, any other specialist reports that may be relevant to your case, to your medical condition, whether you have certain infectious diseases such as active tuberculosis or syphilis, or whether you've been in close contact with others, and how this illness can affect the other people living in Canada. So the government has to seriously consider the impact in terms of public health and epidemiology of your being a part of the Canadian population, even temporarily. And in light of our global pandemic, you can understand danger to public safety. IRC considers the risk that you face of sudden incapacity, any unpredictable or violent behavior that may endanger the public. These are things that are to be considered. And thirdly, whether your unique medical condition and the treatments that it will require could negatively affect the wait times for other Canadians who are in need of health services. And also whether the need to manage your illness will cost more than the government has deemed reasonable. So this excessive demand cost threshold is a limit that the officers will use to determine if the cost of an applicant's health and social services would exceed the Canadian average. That's something that is determined by Parliament based on consultations with those in the field. If not, so it will evolve. There are exceptions, of course, refugees and other protected persons, and certain persons who are being sponsored by their family members, like dependent children and spouses. They are exempt, as I mentioned earlier. So these figures evolve naturally as costs evolve, and so the cost threshold will never be the same. It changes depending on whenever the government takes a snapshot of what it costs right now. So in 2019, the cost threshold was 102,000 over 5 years, or $20,000 per year. So if the cost of your treatment will exceed this figure, it will be deemed excessive demand, and you may well be deemed inadmissible unless there is another factor that would make you an exception. If the IRC believes that you're medically inadmissible, they will send a letter explaining the reasons. It's called a procedural fairness letter. And as I mentioned earlier in the criminal inadmissibility discussion, that letter is also possibly dispatched if your inadmissibility is discovered upon application. So this letter is called a procedural fairness letter, and is received before a final decision is made on the application. But of course, you have an opportunity to rebut and to provide evidence. Finally, we're going to look at refusals based on misrepresentations in our last few minutes. So, as I said earlier, it is a very serious crime to lie or send false information or documents to Immigration, Refugees, and Citizenship Canada. Full disclosure is essential, and that is in order to protect the health, safety, and well-being of Canadian citizens. No person other than a Canadian citizen or a registered native Canadian, Indian, has a right to entry to Canada. All other persons must seek permission. And if in seeking permission, we are not truthful or we misrepresent ourselves and our credentials, then we open ourselves up to possible criminal prosecution and certainly to being deemed inadmissible. So document fraud involves either false or altered documents involving and including but not limited to passports, travel documents, visas, diplomas, high school certificates, police certificates, any kind of credential, documentary evidence of who you claim to be that's falsified is fraudulent. Submitting false documents or information will result in a refusal of the application and can also lead to the following consequences. They may forbid the applicant from entering Canada for at least 5 years. They may give the applicant a permanent record of fraud with the IRCC. They may remove the applicant's status as a permanent resident or citizen even. They may initiate proceedings for criminal prosecution, or they may remove the fraudulent applicant from Canada. So it's very serious. I'll give examples as we close. Submitting false documents or information will result in a refusal of the application and can also lead to the following consequences. They may forbid the applicant from entering Canada for at least 5 years. They may give the applicant a permanent record of fraud. They may remove the applicant's status, and they may also remove the applicant themselves. So Section 40 of the ERPA outlines the rubric, how they explain what it means in law. So some examples of material representation or misrepresentation that could also induce an error would be the failure to declare that you have been refused a visa from another country, providing a document that's found not to be genuine, failure to mention a family member, failure to declare employment experience, or declaring employment experience you do not have, and engaging in a non-genuine marriage. So a lot of people, they try to make their applications seem more impressive on the hopes of securing more points. But if you submit documents and you materially misrepresent yourself, then there are dire consequences. So people do all kinds of things and create all kinds of ways to circumvent the immigration process. And essentially, it deems one inadmissible. That's essentially what this section of the discussion is about. And finally, as we wrap up, financial grounds. Financial grounds. There are financial requirements set out by the Canadian government for temporary and permanent residents alike, visitors to the country. A foreign national is inadmissible for financial reasons if they are or will be unable to or are unwilling to support themselves or any other person who is dependent on them and have not satisfied an officer that adequate arrangements for care and support other than those that involve social assistance have been made. So self-sufficiency, financial self-sufficiency is a very important component of immigration to Canada. The Canadian government does not wish for visitors to become a burden on the economy, and so they need to be satisfied that visitors are aware of how and have made steps and plans to support themselves and not be a burden on the economy. So Section 21 of the ERPA grants an exception to this rule for protected persons, but all the persons need to satisfy the minimum necessary income thresholds. How is this overcome? This is overcome with evidence. Evidence. So we need bank statements, current or past employment information, letter of employment, pay stub, letter of support, anything to substantiate your income. Documentation that demonstrates inadmissibility that may be relied upon in determining inadmissibility may include evidence of dependence on social assistance, benefit checks, cancelled receipts. As I show you in the examples, even using a credit card unauthorized has resulted in this section of inadmissibility being triggered. So here are a few court cases as we close in the last 2 minutes. Trevor Clive Montgomery is a citizen of Bermuda and a father of Canadian-born triplets. Whilst applying for his travel visa, Mr. Smith responded no to an online application question when he should have responded yes. The question relating to Mr. Smith disclosing that he had been charged with criminal offenses in both the US and Bermuda. A procedural fairness letter was sent to Mr. Smith advising him of the potential misrepresentation and providing him the opportunity to explain himself. Mr. Smith claimed to misunderstand the question, arguing that because his US charge was dismissed and his Bermudan charge was expunged, that in his mind they were not relevant for disclosure. The officer believed that Mr. Smith's incorrect response was not due in any part to the question being vague or misleading, subsequently rendering him with an inadmissible status for misrepresentation. On the judicial review, this decision was considered reasonable and Mr. Smith's application was dismissed. So, Mr. Smith responded no in the online application question having to do with his criminal history. He should have responded yes, and he was found inadmissible. He took it a step further. he asked for judicial review, and the case was upheld, and the decision was upheld rather, and his case was dismissed. Next, we have 2 minutes remaining. Melanie Abulok, she's from the Philippines. She applied for a temporary resident visa to visit her boyfriend. She's currently unemployed, though she declared she had 3,000 Canadian dollars and a daughter in the Philippines, pardon me. She's not married, and neither is her partner in Canada. She put her daughter's address as her parents' address and her address as elsewhere. She stated that her partner in Canada stated that they were romantic partners and that he would be financially supporting her during her stay in Canada. However, her daughter was not living with her, and the officer was not convinced that Miss Avila would return to the Philippines, and rather they saw economic benefits to her staying in Canada, and as such, they dismissed her application. So it can be very complicated. So those are 2 very simple examples, one having to do with criminal and the other having to do with misrepresentation. There are myriad examples that we could name that would satisfy the criteria for inadmissibility, but nonetheless, I think it's important to discuss it. And I'm sure, as I said, in this further discussion, we will see so many more examples of how persons impugn themselves and leave themselves open to being found inadmissible for lack of disclosure. So thanks for your time. Just on time. And I hand back over to the chair. Thank you.
Thank you very much, Brian. That was a comprehensive presentation. It covered everything, and it actually, I think it should give people a heads up to understand how important it is to know their circumstances, evaluate their circumstances, and take care of them before the start of the process. Because, as I said earlier, it might be too late if you don't attend to those things, or if you misrepresent, and at the end of the day, and if you don't come clean, at the end of the day, you lose thousands of dollars, you get a refusal, you get a ban, and Canadian doors are closed on you forever. But that's not the end of the story. This information is then shared with other parties. For example, US and Canada share information with each other. So is the case with the UK and Australia. So all these big guns in immigration industry, all these nice destination where people want to go and live, UK, USA, Australia, they also would find these Canadian findings relevant in your case and can cause a lot of problems. I remember one instance, one client approached us. That was in 1994, I guess, and this guy was an entrepreneur. He applied as a businessman. He was interviewed at the Canadian High Commission in Islamabad, and the officer said to him that your net worth is really very, very impressive, and you are a self-made person, very nice business, and everything is fine. We would like to welcome you to Canada, but it appears that you're paying very little taxes. And how come is it possible? And the guy explained that it is perfectly normal in our country to not pay taxes, and the reason is that the government doesn't respond, doesn't reciprocate, doesn't give us the facility against our taxes. So we might as well don't pay, and no one pays taxes here. And if someone is nabbed, then there are ways out. We can pay some money, bribes, we can buy people. And the officer said, well, I really appreciate you are very, credibly advising me about the tax evasion culture in your country, but I am sorry, I have to refuse your application because tax evasion is an offense. Even in your own country, it is an offense, and it's a big offense in Canada too. So what guarantees that if you are practicing this tax evasion in your home country, you won't do that in Canada? And since you have already admitted in front of me that you have been doing it, I cannot allow you. So what we are trying to say over here is that it's not a matter of just calculating your points and then voila, you're coming to Canada. You will be subjected to a lot of checks, background checks, security checks, criminal checks, medical checks, financial checks, and then only you will be allowed, and then only you'll be considered. So it is very important, and that is why I said this topic is really very, very, very interesting, and I always give it a lot of weightage whenever a client approaches us. Not only that we discuss their points, their eligibility in one of the programs, but we also discuss all these matters so that we are not disappointed at the end of the day when the application is concluded. So that's how it was. But thank you very much, Brian, for your contribution today. Everyone appreciated it. Thank you very much. Okay, so Noman Saab, I think we should go ahead and attend some questions today. There are a lot of people who joined us today. And let's take the first question, which came from Mujib Abdullah. It says, I just want to ask if I need IELTS. I'm Mujib with PhD electronic engineering degree and experience of 7 years. So Mujib, if your question is about the exemption for IELTS, that's not possible. Yes, your qualifications are outstanding, and I'm sure that you're fluent in English. But even if you're a native speaker, if you're coming to Canada under the Federal Skilled Worker Program, you will be required to go for your IELTS test, and that is important. Okay. So Qazi Suhail is saying, what is the scope of HVAC skilled worker? So basically, there is no occupation list if you look at the skilled worker program, but there are provinces where this particular occupation could be in demand. If your question is related to immigration, we can make an assessment of your eligibility. If it is related to securing a job, then we are not the professionals to approach. You need to deal with a licensed recruiter in Canada. That person can help you. Let's take the big question that we had. Okay, it covers the entire screen and covers your face too, Khaja Saab. He had a small session with you when you visited Karachi. I want to ask just one question. Currently, my wife, CRS is 467, and EE draw is not happening due to COVID-19. So first of all, Mohammed, the EE draw have been happening continuously, more vigorously, and frequently. So it's not that it's not happening. It is happening. Moreover, she's turning 32 in April. Eventually,
perhaps might be addressing to the federal skilled worker ones, which he's been waiting for desperately, I guess.
No, but there was okay. So there was a little bit of a gap in 2020, but then it started now in 2021. We are still in. We are just in February, right? So we have the entire year in front of us. So they will eventually happen. Her score would be reduced, of course, should we opt for French. So you need to do anything that can increase your points. So French, of course, is something that's going to get you more points. But you can also look into the possibility of getting yourself selected in one of the PNP programs. So do get in touch with us. We might be able to discuss way around. Haji Khan is saying that he's a neurophysiologist and he's working in Doha, want to move to Canada. What IELTS score do I need to apply for skilled worker program? So the minimum requirement is 6 bands in each component of IELTS. But naturally, that is not going to get you competitive ranking score. So you need to do your best. I'm sure as a professional who's working in Doha, your English is good. All you need to do is to prepare and target the highest, because unless you target the highest, you don't get to your desired good 7, 8 bands, right? So if I say 7, then you're going to score 6. So it's better that you target the best. Shazad is saying, what is the future of nurse and pharmacist? Well, they are in demand in Canada. They are both regulated occupations. So naturally, if you come here as a nurse or a pharmacist, you would not be able to practice right away. You'll have to do your licensing, and you have to go through the maybe upgrade your qualification and do certain extra courses in order to be eligible as an internationally trained pharmacist or nurse. So you can look into the regulatory bodies that govern these two professions and get in touch with them. They'll be able to guide you. Ibrahim is saying he has IELTS general training 5-band experience in logistics 6 years. Is there any chance I can be expected as an immigrant? So basically, the minimum requirement is 6. There are certain provincial programs which might consider you with 5 bands, but I'm not too sure about your occupation being listed there. We can determine that, and you can get in touch with our team, and we'll let you know. You have our website, www.amirismail.com. You can do that. Septan is saying that she wants to move to Canada. She's a teacher. So yes, we assist a lot of teachers. They can come to Canada in different subcategories of teachers. Like, you could be a
Early childhood.
early childhood teacher. You could be an elementary teacher. You could be a college teacher. So whatever your case may be, we need to look into your profile, your age, your educational qualification, your language skills, and we can make an assessment. Someone is asking, is there scope of 3 years diploma holders of mechanical technology and BS computer science, and is IELTS a must requirement for? So IELTS is a mandatory requirement everywhere in all provinces. Am I correct, Khwaja Saab? Is that a correct statement? Yeah, okay.
That's
so
right.
IELTS is mandatory. And based on your qualification and there are other factors too, like, we need to look at your age bracket. We need to see how many years of experience you have. The best way to do that is to send us your CV at info@amirismail.com or complete our assessment form online on our website, and we can make an assessment within 2 business days. So Saptan has a further question, follow-up. In fact, information on her experience. She has 17 years of experience. Mehani has joined us again. Good to see you too. Thank you for joining us. Ibrahim has one more question about working visa in British Columbia. Is that available? Okay, so working visa is issued to you, or work permit is issued to you once you get a job offer from an employer based in Canada, and that job offer in most cases is required to be validated by the Canadian Labor Department. So it's not that working visas are available. You will be applying for a working visa when your employer would apply for a labor market impact assessment for the job that they wish to offer you. And subject to that job offer getting a positive LMIA assessment, you can then apply for a work permit based on that. And it could be anywhere in Canada, not necessarily in British Columbia. But yes, mind you, there are a lot of people, con artists in the local markets. They are selling visas. And mind you that your recruitment consultant, your immigration consultant, or your employer, no one can charge you any money. It's against the law, and it can put you in trouble as well. So be mindful of that. Mohammed is asking, is American health certification acceptable in Canada healthcare sector for getting job and immigration? So you can get in touch with the regulator, actually, the Canadian Medical Council, to figure out that. I've seen that Canadian provincial regulators in the health industry, they are very strict. I've seen doctors coming from UK, they're UK qualified doctors, and finding it difficult to get a license. They have to go through the licensing procedure. So it's just a matter of getting in touch with the regulator of the Canadian Medical Council or the provincial level council, and they'll be able to guide you. Okay, so Shazad is saying, is provincial nomination open? And he heard that it is closed. So provincial nominee programs have never been that active that they are now before. So they are indeed open, and they are playing their vital role of selecting appropriate candidates, professionals that suit their labor market. Surya is saying that she's MBBS, 43 years of age, 11 years experience. Is she eligible for PNP? So Surya, I think you got in touch with us a couple of years ago as well. At that time, you were 41. So as you grow in your age, you start losing points. Yes, PNP could be the only option you might have. And if my memory is correct, 2 years ago, we had a consultation as well. If that is the case, then we can perhaps get back to you with more information on the procedure to follow to start the process with us. And she's also provided information on her IELTS. Javed is saying, appreciate it. Thank you very much. Fizan saying, I have a job offer from Quebec company as an engineer. Can I use it to claim 50 points? So your job offer should also be validated by the labor department. So it's not a matter of just getting a job offer on a piece of paper. It has to go through the process, and then you can, of course, claim points. Haji Khan is appreciating Brian. The spelling is incorrect, Brian. I understand it was an unintentional mistake, but thank you for appreciating. It was indeed a very comprehensive and informative presentation. Okay, so let's move. Sheikh Mohammed is sending me greetings. And he's asking, when are they going to open immigration? I need to ask you, when did they close it? Never closed it. It's open. Yes, the borders might be closed, and even the travel is, there are exceptions, even for travelers. So immigration is pretty much open. It's just a matter of finding out if you're qualifying or not. So get in touch with us. We'll make a free assessment of your eligibility. And there goes my colleague, Tanya. Thank you for appreciating. It's basically Brian's effort, but thank you for the appreciation. Tanya and I graduated together from Seneca several years ago, and she is an excellent colleague, very helpful. Okay, so I think we have attended to all the questions for today. And if you wish to get in touch with our team, you have our contact information. I'm going to show the slides right now. We are located at 100 King Street West in Toronto downtown. And the office where Khwaja Daman is sitting right now is Suite 706, 7th floor, Kashif Center. We have our phone numbers mentioned as well. And the email address is info@amirismail.com. So if you have further questions, and if you're watching this broadcast as a recording, feel free to leave your comments, and we'll be happy to attend to them. And we all usually go online every week on Saturday, 11 a.m. or 12 p.m. EST. And we hope to see you guys again next week. Until then, we say goodbye to you.
Bye.